When a hospital makes a catastrophic mistake, there's a playbook that gets activated in the first 24 hours. The family has no idea. Most attorneys don't know either. I'm Masten Childers, and today I've brought Adam Havens from Whiteford. We're talking about what happens when hospitals close ranks, why the system is designed to protect institutions over people, and what it takes to fight back. This is It's Not Fair, Episode 2. So, Adam, we've got Adam Havens here with us today from Whiteford. I've known Adam, over 40 years at this point.
That ages us a little bit, but yeah, over 40 years.
So we went to kindergarten together back in the day and grew up together, and now we have the pleasure of working together.
Yeah, it's great.
Yeah. Before coming over here with us, Adam was a 20-year med-mal defense lawyer, had his own firm. We had many battles against each other, and we're lucky to have him here on our side now, and especially today to talk about, why it's not fair the way hospitals treat people after they've made a catastrophic mistake.
Yeah. Thanks for having me on. It's been a pleasure to work with you after working against you for all those years.
Right. So. Adam, let's just get right into it, man. When's the first time that you saw a hospital go from cooperative to completely shutting down, icing you out?
Well, it actually happens pretty frequently. I think that people in the public at large today, you still think of your local hospital as a local entity, and the reality of the world today is that hospitals are large corporations, usually owned by some outside entity that you've never heard of, and they own a whole host of these hospitals, which means that they have a protocol for what happens when something goes bad.
Sure.
And sometimes it happens as quickly as when the patient's still in the facility.
Yeah.
They've got a policy, whether it's the event or something that a staff member brings to them. They will shut things down immediately, get lawyers involved, get their risk department, lots of them call it quality control, get those involved sometimes within hours of an event happening.
Sure. I think what a lot of people don't realize is where it may be a doctor or a nurse or some sort of medical professional that causes the mistake, it's the hospital that does the cover-up, right?
Absolutely.
Yeah.
It's the hospital, it's the institution, the brick and mortar institution that takes over and runs the show. Something that people don't really realize today, again, things in the last 25 years in medicine have shifted dramatically as far as what the business model for these facilities and for physicians are. Most of those physicians that you're dealing with are employed by the facility. That wasn't the case when we were growing up. They were independent contractors. Today, it's more of a 50-50 split. So you have to realize, even if it's a physician that makes a mistake, it's the institution that's going to step in, and they step in right away.
Sure, and they a lot of times cut the doctor off or the nurse off. They're like, listen, we get it. You have your side of the story, but we're going to control the narrative here.
Absolutely. And sometimes, as life happens, those people don't work for that facility or that entity anymore. And then they sometimes just get lost in the fog. And that's one of the things I think we'll probably talk about today. But it is certainly, when you're thinking in terms of litigation down the road, something that's vitally important, because those people end up giving a witness statement to a risk manager or a quality control person, and then they disappear.
Right. And and that's why it's so important. I assume you agree that you got to hire a lawyer that understands how this stuff works, right?
Absolutely. Yeah. Absolutely. It is that is probably the biggest concern when you're shopping around, looking at lawyers, interviewing people, talking to them. It's the experience, but it's also knowing the system.
Right. Yeah. A lot of times families hire lawyers thinking they're protected, and then unfortunately that lawyer doesn't know how these playbooks work, and or how the evidence can disappear, and things can go awry before you even really get going.
Right. I think it's important to realize that medical negligence cases are incredibly complex, and they are increasingly complex.
Yeah.
And when you've got a lawyer that is inexperienced in the field, they may not know the right avenues. They might know to get the medical records, but then what? You're going to have to evaluate a case quickly, and not just evaluate whether it's a good case or a bad case, or whether something really happened or not. But you also have to be thinking about, you've got a range of experts that you're going to need to be hiring and speaking with quickly. Sometimes these things come to us and the statute of limitations is right around the corner.
Sure.
So you've got to be able to already have that kind of in the back of your mind before the cases even come in the door, before you even know what it's, because if you're that learning curve's so steep that if you're playing catch up, you're never going to catch up with the hospital or the physician's lawyers.
Sure. I mean, right. That's a great point. By the time a client even gets to us, the hospital's had a tremendous amount of time to fix things, to figure out how they're going to defend something, what they're going to do. And
absolutely. So, we always think of it as client comes to us, we start working up a medical negligence claim, and let's say you've got 9-10 months until the statute of limitations, and you think, oh, we've got a ton of time, we're going to be ahead of the game when we file this. No, the hospital or the physician, their people are doing the same thing, and they've had from the time the event happened in most cases.
So, I mean, just generally speaking, a family hires a lawyer for a medical case. They don't realize that they're not protected just because they've hired a lawyer. They got to hire the right lawyer, and that lawyer's got to do the right things. And that's not fair. But that's the way it is, and that's what we're here to do, is to kind of even that playing field, to make it a little more fair.
That's the world we're living in, and that's the hand that we're dealt.
Yeah. So, Adam, walk us through a case where the hospital's institutional response made this significantly harder.
Sure. Say, an expectant mother comes in and she's in labor, and her OB's involved, the hospital's labor and delivery staff's involved, and they encounter a problem, being a shoulder dystocia, which is where the baby is trying to be delivered and their shoulder gets caught up on the mother's anatomy.
Right.
And in the case, I'm thinking of, it was a significant shoulder dystocia where the physician had a great amount of difficulty trying to alleviate and actually deliver the baby. They tried to move on to doing a cesarean section, an emergent cesarean section. They, in the process of doing that, were able to deliver the baby, but after about 10 minutes, a baby can become hypoxic. They can lose oxygen during that time period. And in this instance, the baby was delivered, had significant deficits right from the beginning. An APGAR score, which is kind of measuring how a baby's doing in the first and fifth minutes after delivery, were low. And it was clear that the baby needed to be transferred to a big university, UK in this instance, for a higher level of care, which, the end of the story is that the baby was in the hospital in the NICU for months, has recovered, but still has what we call a traumatic brain injury. And the hospital knew right away that this was a problem from the second after that baby was delivered, probably even before. So I am sure they triggered an immediate protocol where this incident was investigated. The nurses and the physician were interviewed within a day or within a few days. and that patient's file, medical records were all flagged, so that by the time we got involved and we send a medical records request to the hospital, they know that somebody's on it. But by that point, they've already retained their outside counsel, they've had time to look through the medical records, they've had time to hire experts. So we're already behind the ball at that point. They've already closed up shop and have kind of brought up their fortress by the time we even know anything's happened.
Yeah, and you raise a good point. When you're dealing with massive hospitals or even smaller level hospitals, you've got not only the hospital's resources, but you've got their insurance company's resources.
Yep.
And if you don't have the ability, or your attorneys don't have the ability to match or even exceed those resources, you're at a tremendous disadvantage. I mean, not only are you playing catch up, but you're it's like David fighting Goliath, right? And
from many respects,
yeah.
They have the resources and the manpower, both internally and externally. These cases and these claims, medical negligence, even a pretty simple medical negligence claim, is one, just extremely expensive to prosecute. From the time it starts to the time it finishes, you're spending money on experts, you're spending money on traveling around because you have to go and see these people. You're spending money on medical graphics, even animations. It's expensive, it's complex, and it is time consuming.
Sure. And I think that's again another great point that clients and sometimes attorneys don't understand, is that these medical negligence cases, they don't settle early. These are not typically the kinds of cases like you hear about a car wreck settling quickly, or even a slip and fall, or sometimes a nursing home case. But pure medical negligence cases don't settle quickly.
They just don't.
Yeah.
It's the nature of the beast. Even the most egregious of cases, you and I are familiar with a pathology misdiagnosis case that resulted in cancer, a stage 4 untreatable cancer in a patient who was a client of ours. That took until we had identified our experts to the other side. So we had done all the early discovery. We had done depositions of their clients and ours, and we had identified who our experts were before the target defendants settled.
Yeah. I mean, it's actually the norm for a complex medical negligence case, I think, to cost in terms of case expenses, not attorney time, not fees, but case expenses, expert fees, deposition fees, et cetera, to cost in the hundreds of thousands of dollars.
Without question.
Yeah.
And to go along with that, it also costs hundreds and hundreds of hours of work time.
Yeah, absolutely. And and something that I think it helps them understand a little bit, and so I understand it when we're practicing these cases to some extent, is that these are these doctors' professional reputations, right? And
right.
So when you allege that a doctor has been negligent, that doctor, more likely than not, or more often than not, has a consent to settle clause in their insurance agreement. And so they're not going to allow the insurance company or the hospital or the facility to settle quickly, because it's their reputation. They want to defend it as best they can. And so I think a lot of what you and I do, or we do as a group, is we have to educate that doctor why they were negligent,
right?
Why what they did wrong caused our client harm, and that takes a lot of time, a lot of effort, a lot of money to convince them to finally realize, okay, maybe I did do something wrong here, and we ought to try and resolve this. But that's not a quick thing.
It's not quick. I think that generally a medical negligence case, from the time it comes in the door until the time it's resolved, it's years, and 3+ years usually.
Yeah.
But I think it also, that point really kind of highlights why it's important to have somebody that's experienced and knows what they're doing.
Yeah.
Because You need to, if it's a case that you think should settle or will settle eventually, you need to have your foot on the gas and pressure the other side just the same way they're pressuring you.
Yeah.
Physicians that have consent to settle policies, they are not going to consent usually until all the experts have been deposed and there's a trial date looming. And that's when it finally becomes real for them.
Right. And, that's not fair. And people don't understand that. And that's what we're here to do. I'm proud of the fact that you're right. While medical negligence cases, I think 3 years is a pretty standard amount of time given everything that we've just discussed, plus the way the courts are backed up. But we've been pretty successful in expediting those where it is not uncommon that we can get them done in a year and a half, but that's light speed.
Well, it's light speed, and it is highlighting how we put our ducks in a row the best that we can before we get it filed, so that way we can apply all the pressure and we can be the ones with our foot on the gas.
Right. Sure. So, Adam, we get asked a lot because, we do a lot of medical cases. Candidly, they're my favorite kinds of cases to do, and I know they're yours.
Yeah.
And so when should an attorney refer a medical malpractice case instead of trying to handle it on their own?
Yeah, it's a great question because, we're, as lawyers, we're educated. We like to think that we can handle things, anything that comes in the door.
Yeah.
I think as a general practice attorney, somebody that does not focus on medical negligence, referring it to a specialist as soon as possible is key. The longer you wait, the harder it becomes for us to play catch up.
Oh, sure. And we've all been in the position where an attorney calls us and they need help, but it's so far down the road. We have so many mistakes, and mistake may not even be the right word sometimes, but they just haven't done everything that they need to do in order to get the case across the finish line. And we're put in a position to play catch up. And sometimes it's just harder, right?
It is. It's just harder, and there's a lot of Monday morning quarterbacking that goes on, but not that another lawyer hasn't done things exactly right. It's just the experience really shows, and you can't do this bit by bit. You've got to have a plan and be executing your plan 3-4 steps in the future, especially with experts in discovery.
Yeah, because to our earlier point, if you're not in a position as an attorney to front, hundreds of thousands of dollars in expenses, you really, for no fault but that issue right there, is that you just can't afford to do it. You're going to practice the case differently than if you have the resources available to do exactly what it is you want to do. You may do okay in the long run, but the other side recognizes that you can't really practice it the way you should be practicing because of financial considerations and blah, blah, blah.
Absolutely. So, if you're doing it on the cheap, you might get a result, you might get a settlement. It's going to be less than if you had fully worked up the case, had it analyzed, and had the right experts in the right spots ready to go. But then the next case that comes in the door, the same insurance company, I think something that not everybody understands. There's only a handful of insurance companies that write policies for physicians and hospitals. So you're dealing with the same people all the time. Your next case that comes in the door, that's going to be your reputation with those adjusters in that insurance company, is that you do it on the cheap. You'll take less money to settle a case than it's worth because you're not prepared.
Yeah. And then, we are fortunate for ourselves and for our clients. We have hundreds of cases, medical malpractice cases pending in Kentucky, and there are there's only so many medical providers in Kentucky. And so if we've got hundreds of cases, we've got dozens of cases against most medical providers out there.
Right.
And so we know the playbook. We know what their typical defense strategy looks like. We know the experts to hire to go after these folks, and the lawyers and the insurance companies involved on the other side know what we're capable of. And, not to brag too much, but you and I and Justin and Sarah have the largest med mal verdict in Kentucky we got last year.
Correct.
And it was a tremendous win for our client, a horrible, sad story, but that resonates with the insurance companies and the providers out there. They know we're willing to try a case, and that we're willing to spend the money to get to where we need to get.
Right, you bring up an incredible point, because the insurance companies and the adjusters that are, they hold the purse strings in these situations. They know who's willing to try a case. Yeah. And they know that there are a lot of lawyers out there that are doing this that aren't. Yeah. They're just not willing to try a case. So that the closer they get to a trial date, the less money they're going to take, because they're not going to try it.
All right. And none of this is fair. It's absolutely not fair. So,
yeah.
But that's, again, what all you can do when things aren't fair is try and even the playing field or get ahead of the other side as best you can.
That's right. And it is preparation. Preparation's the key.
Yeah. All right. So, Adam, let's say that you're an attorney. You're not typically a medical malpractice attorney, but you get a great medical malpractice case in, and you decide that you're going to go forward with it, right? So what are some of the things that those attorneys who decide to take it and handle it themselves need to do in the first 24 hours to make things as fair as they possibly can for their client?
Well, after all the things, as far as, you got to meet with your client, you've got to get a list of who their providers are. You have to have your brain wrapped around what the allegation as your client sees it is.
Yeah.
And then the next step would be make sure you get a HIPAA release. When you sign your client up and sign them to the contract, you need to get a HIPAA release. If it is a wrongful death medical negligence case, you're going to have to get an estate filed before any provider is going to allow you to obtain the medical records. Once you get that HIPAA release, request all the medical records from the people that your client has told you they saw. The facilities, you need to get it from the facilities and from the individual physicians, so you get their office notes. Mm-hmm. You also need to know that things like radiology and pathology will take a separate request. So if you want Baptist Lexington's medical records, great. If you want their radiology and the pathology, you're going to have to send separate requests to each of those.
Yeah.
In situations where the hospital knows it's coming, they're going to slow roll you. They're supposed to get back to you with the records within 30 days. That doesn't always happen.
Yeah.
So you have to stay on them. You have to badger them for those things.
Yeah, so in Kentucky, everybody gets one free copy. Their first copy of their medical records are free, right? And that's a big deal. In a lot of states where we practice, that's not the case.
Right.
And so we have dozens of people doing exactly what you just described. And we have, seriously, we have dozens of people that their only job is to request the medical records and then follow up with those providers to get the records.
That's right. I get a weekly update on the cases where we have outstanding records requests and what the status of, I say badgering them, but following up on those requests are.
Yeah.
Because in a medical negligence case, you can't go anywhere without the records.
And you said another thing that's important. You said, when a hospital knows it's coming, they're going to slow walk it, right? Well, to our earlier points, the hospital, generally speaking, is going to know that a potential medical malpractice suit is coming the minute that the event goes wrong.
Right.
And so what do you think about the importance of a preservation letter?
That we're fortunate in medical negligence because they're required to preserve that by law anyways. It's not like, I know we've handled some gun cases where a gun there's a product defect or alleged product defect, and you need to send information to preserve all of that evidence. The records are preserved up to, it's a number of years and it's a moving target, but it's years.
Yeah.
Pathology specimens, radiology, all of that gets kept for a number of years. Again, that sounds like you got lots of time. If something happens, time is always of the essence, right? You don't want 3-4 years down the line to be looking for a pathology specimen so that you can get a recut, and that doesn't exist anymore. So you don't really need a preservation letter, but you do need to know what to request and that everything takes separate requests. You also need, if the case gets filed and you go through discovery, I think you need to get an audit trail.
Yeah.
Now it's not like when I started and all the medical records came were either dictation, where somebody has talked into a phone and it's been typed out, or was handwritten.
Sure.
Now it's all electronic. The nice part with electronic medical records is that there's an audit trail that comes with it, so that it shows you every time something's been changed in it, and it gives you a date and a timestamp. So you can actually construct a real timeline with what's happened.
Oh, sure. I kind of miss the days when when you get medical records and you get an audit trail and you realize that people would go in and had changed the medical record to their benefit. That essentially has all but stopped because they've caught on and they realize they're going to get caught. But it used to be that doctors would go in, doctors or nurses or facility folks would go into the medical record and change the record so it would help their narrative.
Absolutely. And now they quickly realized that's a non-starter, because this system, this EMR, picks up everything that's changed. It tells you what's changed by who. And sometimes just the appearance of going back and looking at something is worse than just dealing with it how it is.
Sure.
The old days, you used to have to go and dig through some basement in a hospital looking for a carbon copy to see if the pin color was different. Luckily, we don't have to do that anymore.
Yeah. And you're right. Timing is absolutely of the essence. And one of the things about timing in Kentucky, while we're very fortunate that tort reform has not ruined, plaintiffs' rights in Kentucky like it has in so many other places, but we've got pretty short statutes of limitations.
We do.
For medical malpractice, generally speaking, it's 1 year from the date of the injury or from the date in which it's discovered that the injury was a result of medical negligence, but you don't really want to rely on the discovery rule. So you need to stick to a year from the date of the injury if you can. But, you mentioned wrongful deaths and estates. A lot of attorneys ask us frequently, what happens when my patient or when my client died as a result of the medical negligence? Does that change the statute? Yes, it does. It's important that you understand that if the death is the result of medical negligence, the statute of limitations is extended by the wrongful death statute, and it's no longer a year from the date of the injury. It's a year from the date of the death, or a year from the date of the appointment of the administrator over the estate, whichever is longer, not to exceed 2 years, right? And so if you have a medical negligence event that happened, let's say in November, and then unfortunately you pass away in January, then that statute of limitations runs from that January date, essentially, instead of the November.
That's right. It's also conversely critically important, and this is why experience matters and being in the right hands matters, because you need to be able to tell or have somebody quickly tell you that death is causally linked to the alleged negligence, because if you just assume that and then you can't prove it, you might blow your statute of limitations.
Right. And again, that is not fair, but the rules are the rules, and they're designed to try and make things as fair as possible. You just got to make sure you find a lawyer that knows what those rules are and how to play in the field with those rules. And that brings me to one final point about this portion is, what do you do in the first 24 hours? You're right. Request the medical records, make sure you get all that buttoned up, and then the next step, in my opinion, is to get it to an expert very quickly. To the tort reform point, Kentucky tried all kinds of different things. Ultimately, we ended up to where we have to have what's called a certificate of merit filed with the complaint. Either the lawyer or the expert can sign it. But essentially what it is saying is in Kentucky, you cannot file a claim for medical negligence unless you have consulted with an expert, and that expert is willing to testify, or you're going to be able to have an expert that will testify at trial, that the doctor or the nurse or the hospital breached the standard of care, and that standard of care caused the damages that we're talking about here. So you got to get those records to an expert quickly. These experts are typically practicing physicians in similar fields, and they are busy.
Right. They have a career. They're usually doing this nights and weekends type of thing.
Yeah.
So you need to give them time to be able to look at that. And sometimes you're sending them thousands of pages.
Yeah.
So you need to be able to give them time. So that's why you need to do these things quickly.
Yeah, and you need look, the quality of your expert, sometimes the value of your case rises and falls based on the quality of your expert. And the defense bar and the providers they defend know the players out there. They will always have better access to experts than the plaintiff, because most doctors don't want to opine or be critical of another doctor.
Right.
And so they're already at an advantage in the bench of experts that they can pull from. We are at a disadvantage trying to find doctors out there that are willing to come in and criticize another doctor. Mm-hmm. And so you can't just, there's plenty of doctors out there or experts out there that will give you an opinion that you want, but you got to make sure they're the right person, because they're going to get destroyed, which will then reduce the value of your case, your client's case. So you got to be careful.
Oh, absolutely. You don't want to be dealing in a case that involves a specialist and you have just an internal medicine physician who's giving you an opinion on the side.
Right.
You're going to get destroyed if you do that.
Yeah. So, Adam, what's the one thing that attorneys really need to understand about everything we've been trying to talk about today?
You know, I think the one big takeaway point for attorneys is these cases are beasts.
Yeah.
They are absolute beasts. They are time consumers. They are money consumers. They are resource consumers. So you need to move quickly. You need to have all the resources at your disposal to effectively take and run with one of these cases. And you need to really know what you're doing in terms of hiring experts and developing their opinions. You know, again, medical negligence cases usually require, these days, we'll hire 3 or 4, maybe 5 experts on a case, but you got to prove not only that somebody did something wrong, you got to prove that caused the injuries that they're complaining of. And that's going to take usually a multitude of specialties. So attorneys need to know that's what you're getting into.
Yeah, and it's a great point. And I think that generally speaking, when you hear all of this in a vacuum, it just seems like it's just so unfair and so one-sided. And to some extent it is, but I do think it's important that everybody understands that there's a reason that things are this way. And none of us are benefited by doctors that are afraid to practice. Right. And so your doctor, your medical providers out there need to be able to take calculated chances, take calculated risks when it comes to treating you without the fear of a lawsuit.
Absolutely. Medicine's not a 100% specialty.
Right.
Even though we might try to make it that way, it's not. And medicine is not practiced by algorithms.
Right.
Judgment is a really big part of practicing medicine. And that goes back into, for attorneys, that goes back into your evaluation. There are a lot of cases that come in the door that a bad outcome has happened, but it doesn't mean that there's negligence.
Right.
And that is why your evaluation needs to be accurate, but it also needs to be quick.
Right. And that just goes to show, even though you may think so, and if you know me, you know I think this way too a lot of times, that hospitals and medical providers are evil, right? And so, but truthfully, it's not that they're not doing this because they're evil. They're doing this because that's the way things are designed, and that it's the way that they have to be in order to protect their institutions and protect the practice of medicine.
Right.
And so when you understand that, and you understand they're going to throw all the resources they have to protect those things, you just have to find the right partner in your law firm or in your lawyer that can go against those people and match their resources and exceed them and just even the playing field.
Yep, it's a critical decision that you have to make on your part to advance your best interest.
Right.
It just is. That's the unfortunate nature of the beast you're dealing with, but that's the decision you have to make.
Yeah. Adam, thanks for being here, man.
Thanks for
I appreciate
having me.
it. Yeah.
I really appreciate it.
This is It's Not Fair, a podcast about the moments that determine outcomes before most people know the game started. I'm Masten Childers. Adam Havens is a medical malpractice attorney at Whiteford and Peterson. We're not here to sell you on our firms. We're here to talk to you about how the system actually works and what you need to know before you need to know it. Thanks for listening.